Hello and welcome to Chapter 4, Civil Liberties in Module 2. So the first thing to talk about is the 14th Amendment in 1868. And it's important to understand the context of this amendment. So 1868, we're just following the Civil War, bloody battle versus the North, the U.S. federal government, and the Confederate States of America, former states in rebellion in the South. And so that is the context from which this was written. Section 1 is very important. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. And we see in this chapter on civil liberties many different cases that went before the Supreme Court that used the 14th Amendment to make sure that individuals were granted the privileges in the federal government at the state level, as well as the federal level, and due process and equal protection clause. So other sections in the 14th Amendment, which weren't discussed too much in the text, but they're important to also look at. So Section 2 says representatives, this is, of course, a summary, not the actual text, representatives apportioned based on whole numbers of persons in states. So this throws out the 3/5 clause. Of course, there is an exception, and that's non-tax Native Americans, but otherwise all persons in the state are counted. So apportion means the counting to get to the number through the census of how many representatives a state would have. And the right to vote for all males, regardless of race, 21 and over. Of course, this was later changed to 18 and over in the 20th century. Here's the big exception, except if they participated in rebellion or other crime. So this meant that those who were involved in the Confederacy were not allowed to participate in those southern states, as well as or other crime gave kind of a wide berth of who could be excluded from participating in voting. Similarly, Section 3, former Confederates could not participate in government, state, or federal. They could not participate in the military. And this was unless Congress voted by 2/3 to let an individual participate. So they had to vote for each individual at this point. Now later, Sections 2 and 3 were repealed through the Amnesty Act of 1872. And that was the beginning of the end of the Reconstruction era, where the federal government took control of the southern states after the Civil War to about 1877. But this Amnesty Act of 1872, now you had all of these former Confederates who were now allowed to vote and who were allowed to participate in government. And then they started taking apart a lot of the measures put forth by the federal government to allow African Americans to hold office, to vote, etc. Section 4, no debt acquired by Confederate states or citizens will be repaid, meaning the southern states couldn't sue the federal government saying you destroyed our town or you took our property. That would not be repaid. And Section 5, the Congress shall have power to enforce by appropriate legislation the provisions of this article. So the federal government can enforce this, can enforce the Section 1 principles. So incorporation doctrine, and incorporation in this context means that the states now have to follow federal law, that what's in the Constitution for the federal government now applies to the states. And as we talked about, the 14th Amendment, as well as the Bill of Rights, the first 10 amendments, applies to the actions of states and not just the federal government. And we'll go over in a second each of these individual cases. Due process clause. This is in the Bill of Rights, of course, and writs of habeas corpus. These things applied to states as well as federal government. Habeas corpus means a person under arrest must be brought before a judge or into a court to determine if the person is being held legally. It means they have to be told what they're being held for, etc. And if they're not, then they have to be released. Substantive due process, that's the judicial interpretation of the 5th and 14th Amendments due process clauses, protects citizens from arbitrary or unjust state or federal laws. And that'll come into play quite a bit in this chapter, but also next chapter, the civil rights chapter. So selective incorporation, what this means in this context is that the Supreme Court has ruled that specific incidents involving states apply, Federal Bill of Rights and the Constitution of 14th Amendment apply to the states as well as government. But not everything, every matter has been discussed through a Supreme Court case. So there's still many issues that haven't been dealt with, but the assumption, even though it hasn't been addressed, it doesn't mean it's not the law. It just hasn't been addressed yet, and we'll go over that list in a second. So fundamental freedoms, as we read in the text, these are essential to order, liberty, and justice, and in some cases also to morality. And that's been changing over time as we read in the text and also saw in the videos, etc. So rights that states must protect: freedom of press, freedom of speech, freedom of assembly, those First Amendment rights there. And if we look at the list here, this is a breakdown of the Bill of Rights and how they've been addressed in the Supreme Court. And when the Supreme Court rules on an issue, it becomes law. It's called precedent. And we'll discuss that more in the chapter on the judiciary later in this semester. So if we look at the First Amendment, speech, press, assembly, religion, these have all been decided in the Supreme Court and have upheld that states have to follow the federal guidelines. Bear arms, we've seen changes over the years, beginning in the 1920s and 30s, as we saw related to prohibition, and there was a lot of gun violence associated with different groups that were illegally selling alcohol during that time and formed these giant crime syndicates. And more recently, McDonald v. City of Chicago and DC v. Heller upheld that an individual has the right to bear arms individually and not just part of a state militia. So that was decided fairly recently in the last 10, 15 years. No quartering of soldiers, that's the Third Amendment. That has not been incorporated. There's never been a case that's come to the Supreme Court, but it's assumed that obviously that is something that cannot be done. No unreasonable searches and seizures. Many different cases have come before the court, meaning that the states, the incorporation, selective incorporation has taken place where the states have to follow the federal law. Exclusionary rule, that's in the Fourth Amendment as well. And that was incorporated in 1961 with Mapp v. Ohio. And that says that federal law enforcement, or excuse me, state or federal law enforcement cannot acquire evidence illegally. And if they do, it cannot be used in court. Now, there are some small exceptions as we read in the text, but generally that is the rule. And this is, of course, to prevent law enforcement from using illegal means to gather evidence. Just compensation, and we've seen that was upheld. It's from the Fifth Amendment, meaning if the government takes your property, the state or federal government, you have to be compensated justly, and that was upheld as far back as 1897. Self-incrimination, that's the Fifth Amendment, pleading the Fifth, was upheld in 1964. Double jeopardy, another portion of the Fifth Amendment, was upheld in 1969, meaning a person cannot be tried for the same issue twice in the same jurisdiction. So be careful with that one, because that's in the same jurisdiction. So a person can be tried in a criminal court, as we saw, let's say, O.J. Simpson case in the 90s, but then can also be tried in a civil court, even though the criminal court acquitted O.J. The civil court ruled for the plaintiff, and he was ordered to pay restitution to the family. This can also mean that a state court can rule something, and the one could be tried again in a federal court if the federal court applies. And we'll talk about that more under the judiciary chapter. Grand jury indictment has not been incorporated. This means that any case that goes to trial must be put before a grand jury of peers, and they will say to go forward with the trial or not. Interestingly, that's never been incorporated, meaning there hasn't been a case that a state refused a grand jury and was taken to court and there's been no selective incorporation. Doesn't mean it's not the law. Public trial, 1948, as well as other cases, has been upheld. That's the Sixth Amendment, right to counsel, Gideon v. Wainwright. That was an interpretation of the Sixth Amendment language to make sure that right to counsel didn't mean just a right to pay for counsel, but if a person does not have the means to pay for counsel, they will be appointed counsel or an attorney by the court. And so that was solidified in 1963 with Gideon v. Wainwright. Also Amendment 6, confrontation of witnesses in 1965, meaning those who are accused can confront the witnesses either through their attorney or themselves personally. And that was upheld and incorporated to the states at Pointer v. Texas. However, there are small exceptions in the case of minors who were victims of abuse. They can have closed circuit, and the person accused does not have to be in the same proximity with that person. Amendment 6, impartial law and speedy trial in the 60s was upheld and incorporated to the states. Compulsory trial was also in the 60s, criminal trial in the 60s. As far as a jury trial was upheld and incorporated to the states. Civil jury trial has not been incorporated. So far, there hasn't been a case yet at the state level to bring it to federal court and incorporate, though it doesn't mean it's not law. And you have the Eighth Amendment, no cruel or unusual punishment and no excessive bail were upheld and incorporated in 62 and 71, and there's been other trials since. So Establishment Clause, separation of church and state. That's one of the first things that the framers of the Constitution put in there to make sure, with the Bill of Rights, to make sure that there was a separation of church and state. This was to avoid the dominant churches in Europe in the 16th and 17th century. And the case that provides the test for this was in 1971. And it says, in order for any government that's federal, state, or local to work with a religious organization or group, a three-pronged test is required. So there's three things that have to be required. First, must have secular, non-religious purpose. So we see that if it's education with schools, generally that's a secular purpose, meaning to educate the child. Now that's a bit of a gray area. There's many religious schools that perhaps have a lot of indoctrination to that religion as well as other education, or forbid certain types of education. So that's a bit gray, but generally it's considered education is secular. Must not advance or prohibit a religion. That's the interaction between the government entity and the body, and must not entangle government with religion. And there's a lot of gray area there, but generally the Lemon Test has held up since then. Free exercise clause. So this means that you can practice your religion, but it's not absolute. So government interests can outweigh free exercise rights. And this is, of course, the blatant hypothetical here, the Church of Death cannot sacrifice people, even if it's required in their holy book. That's not allowed. So there are limits. You had this pushback, this kind of evangelical conservatism that's always been there, but it really came to a head in the 80s and 90s and through current times. And so they put forth with the conservative Congress this Religious Freedom Restoration Act and required that federal governments have to demonstrate a compelling state interest to restrict a person's free exercise of religion. So this is generally to allow certain practices that, you know, perhaps aren't politically correct anymore, or perhaps are um, bigoted towards certain groups, etc. So parts of it were later ruled unconstitutional at the federal level. The state level still has more leeway there. Many states have passed versions of this, and it's been controversial, you know, allowing for private citizens and businesses in some states to discriminate against others due to their religious beliefs. We have the example of the wedding cake in Colorado, not making a wedding cake for an LGBTQ couple, and that's still under debate in many different states. Freedoms of speech and the press. The Alien and Sedition Act. So just after we get started as a nation under the Constitution, we have the Alien and Sedition Acts come in 1798, which censored criticism of the government, and that was very unpopular and was used by Thomas Jefferson and others in the 1800 election, and pretty much destroyed that group. But they removed it before any judicial interpretation could take place. It just was not very popular and has never been popular since, though it was revisited later, as we'll see in a second. Slavery, Civil War, and rights curtailments. During this time, speech was censored. For example, northern states banned any speech promoting slavery. There was a lot of, that was during the Civil War, and there was a lot of other rights curtailments during the Civil War period, which is not too unusual during times of war. World War I and anti-government speech. You had the Espionage and Sedition Acts of 1917-18. This coincides with World War I, and that prohibited individuals from expressing or publishing opinions that would interfere with the US military's efforts to defeat Germany and its allies. And that was, again, not too popular, but there was a populist movement supporting it, supporting the US and British and French troops, of course. This was taken to the courts, and you have the interpretation in Schenck v. US in 1919, and they said it needs to pass a clear and present danger test, meaning if there's a clear and present danger, which is a bit vague, because of the words or actions or publications, etc., then it could be used to stop such speech. Or later you have different version, and the clear and present danger test was too vague. So in Brandenburg v. Ohio in 1969, the test was replaced with imminent lawless action. So if there's going to be a crime that's going to take place, if it's imminent based upon these words or printing, publications, etc., then actions could be taken by the government to condemn those words and speech and press. So protected speech, you cannot limit through prior restraint, which is you cannot force someone not to say something. And symbolic and hate speech is protected. And definitely you want to check out the video in the module with the hate speech versus free speech. It's kind of interesting what's allowed and what isn't. So hate speech is allowed in most cases, and symbolic speech for now. So unprotected speech is libel, and libel is published, so printed, and it could be not necessarily printed in the old-fashioned press, newspaper, but it could be online and or through media, through television, etc. And libel would be a published false statement that is damaging to a person's reputation, a written defamation of character. But the key here is that it's false. So the onus is on proving that whatever statement was made is false, and that can be difficult in the United States. Some other countries, as we saw in the text, UK and Europe, it's a bit easier to prove libel. In the US, it's a bit more difficult. Slander is spoken word. So the action or crime of making a false spoken statement damaging to a person's reputation. And again, same issue, it has to be shown to be false. Fighting words, this is kind of a gray area, but speech or press intended to threaten or provoke an altercation. And I would say there's a lot of fighting words, especially now in the press, that goes unchecked. However, if it's imminent danger, then that's not protected. Obscenity is unprotected speech, and that defers to state or local interpretation. And then you have issues with the internet, which the text briefly looked at. So obscenity laws generally have gotten less prosecuted. However, it depends on each state. Freedoms of assembly and petition. This hinge on peaceful conduct, and the court has rarely addressed the right to petition. So the right to keep and bear arms. And this was important for anti-federalists to support the Constitution, and through the Bill of Rights that was added to make sure that the anti-federalists and other groups were happy. And they wanted to keep the power of the federal government in check. So they wanted to still allow the state militias, which had operated through the Revolution and through the first incarnation of the United States. And they wanted to make sure that the states had the power to keep any federal government from getting too powerful. And so the Second Amendment was put in there, the right to keep and bear arms. As we spoke about just a little while ago, the National Firearms Act 1934, that's reaction to the mob syndicate crime activity that was enhanced by Prohibition, which was later repealed. And this created an excise tax on automatic weapons and certain shotguns, and basically said that through the court rulings subsequent to this, had said that a person is allowed a traditional rifle. However, automatic weapons and sawed-off shotguns are not protected under the Second Amendment. District of Columbia v. Heller, we discussed briefly, says the Second Amendment protects an individual's right to possess a firearm unconnected with service to a militia, for the state, and for traditionally lawful purposes such as self-defense, hunting, etc. In DC, you see the case there, and that, excuse me, was a handgun ban that was ruled unconstitutional, as well as shotguns to be kept unloaded and disassembled or bound by a trigger lock. These violated, and so they had to go back and make sure that they were following what was the interpretation in Heller. And then you have McDonald, which also loosens some of the requirements for the types of guns individuals can own, loosens to the extent that states can allow more different types of arms purchases. And some states did, Texas, other southern states, and some didn't, California and the East Coast. So Fourth Amendment, searches and seizures. Police must obtain warrant for searches, houses, or offices. There's an expectation of privacy. Interior border checkpoints has always been kind of a gray area, and it's been challenged, though was held in United States v. Martinez Fuerte in 1976, which allowed the checkpoints within 100 miles of the border. And they usually are between 25 and 75, as we know, as we go through them often on the way to San Diego or to Yuma. And warrantless searches have been allowed more and more over the years, as we read in the text. So there has to be reasonable suspicion, and that's been challenged quite a bit. Obviously, with consent, if the person says yes, sure, then they're allowed to search. And in situations with no expectation of privacy, public situations, again, go back to the video in the module. It's much more exciting than me lecturing here, and they go over explaining search and seizure in that video far better than I. The Fifth Amendment, self-incrimination, double jeopardy, and exclusionary rule. So right to a grand jury hearing. Is there a jury, normally 23 jurors, which is quite a lot, is selected to examine the validity of an accusation before trial in a criminal case. Protection against self-incrimination, cannot be forced to appear as a witness against oneself, pleading the Fifth. You have Miranda v. Arizona, 1966, is where we get the Miranda rights. And that's against self-incrimination, but also requires law enforcement to advise a suspect of their rights to remain silent and to obtain an attorney, as we've heard a million times in movies and TV shows. Double jeopardy, the Fifth Amendment is not allowed, which I explained just previously. However, that's within the same jurisdiction. If it's criminal versus civil, that's different. If it's state versus federal, that's different. And the exclusionary rule we went over briefly. You cannot use illegally obtained evidence in a criminal trial. However, they've made some exceptions for good faith mistakes, which is a bit gray. The Sixth Amendment is a right to attorney. That's Gideon and Wainwright. So the state, as well as federal government, must provide an attorney for those who cannot provide their own legal counsel. And right to counsel also begins with first appearance before a judge. So it's not, used to be that later on in the process they would be given an attorney, and usually it was a moot point at that point. Also, the rulings were that, later rulings were that the attorney has to do a diligent job. They can't just sit there and do nothing and just be kind of this creature of the court to expedite matters. Speedy and public trial by impartial jury, right to confront witnesses, all witnesses in a trial, including those for the prosecution. However, there is the instance with minors who were involved in abuse cases where you have the closed circuit television or other ways where they don't directly confront those witnesses. And a jury of peers, and we've read about several cases that looked at racial and gender peers have to be considered, as well as you cannot exclude jurors simply based on race or gender. The Eighth Amendment, cruel and unusual punishment. And this has come up several times regarding the death penalty, life sentences, solitary confinement, and as well as matters related to the war on terror. And the modern cases, Furman v. Georgia was the big one, 1972, and that removed all state capital punishments. So the death penalty laws were all removed. However, the states needed to could come up with something else, and it would be either approved or not at the federal level. But there needed to be a degree of consistency in the application of the death penalty, how it was carried out, etc. This created a de facto moratorium on capital punishment for several years. One of those who was going to be executed was Charles Manson in California, and the Furman v. Georgia stopped his execution. However, in 1976, Gregg v. Georgia, so Georgia came up with a death penalty law at the state level that they felt provided clarity, and the Supreme Court agreed with them. And then many other states followed Georgia's lead and reinstituted the death penalty, especially in the South. And we know Texas is very proud of their inmates that they put to death. However, with Gregg v. Georgia, the mentally ill were protected from the death penalty, as was the case from other court cases to uphold that. Protecting the wrongfully convicted, we have House v. Bell, fairly recently, 2006, which allowed for an additional appeal effort due to DNA evidence suggesting innocence. So this is a new technology that obviously wasn't around in the 19th century or most of the 20th century. And so this now allowed for an additional appeal if there is DNA evidence that may suggest innocence. And we have many DNA-related exonerations before and after 2006. So modern civil liberties, you have the 14th Amendment, which we discussed, which was kind of the basis for a lot of these. Griswold v. Connecticut found states cannot ban contraceptives. Roe v. Wade, there's a right to privacy under the Due Process Clause of the 14th Amendment, and that extended to women's decision to have an abortion. And this was balanced against three factors: the state interests in regulating abortions, protecting women's health, and protecting potential human life. And then we also have the 3-trimester breakdown in that test. That's been challenged many, many different times. And as we read in the text, there is some thought that it may be overturned to some extent, if not in whole, in the near future, as the Supreme Court has taken up some cases that could do that. Lawrence v. Texas, right to privacy extends to private sexual behavior. It's shocking that it was in 2003 where that was the case. The United States, most states didn't prosecute anyway and had long gotten rid of different obscenity and sodomy laws. However, some states, in this case Texas, still had them on the books, and this was taken to the Supreme Court, and they said, no, right to privacy extends to private sexual behavior. And then you have, in 2015, Obergefell v. Hodges, and that allowed LGBTQ couples to marry, and that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. The final issue is privacy issues, mostly related to the laws associated with the Patriot Act, as we read in the text, and subsequent laws. And again, we have a great TED Talk on that in the module, and I'll let you go and watch that, about 15 minutes. And then there's about 5 minutes of questions, which are interesting too at the end to watch. And make sure you watch that, as well as all the videos when they put them in to the module. They're important and they cover the course material. So I will see you in chapter 5.